at NTV.
A very good morning, and we're glad you're still with us here on Morning at NTV. The hashtag on Twitter is Morning at NTV. We are also streaming live on Facebook as well as on YouTube for those that are watching on the internet and indeed across the globe. Welcome to our Kickstarter discussion, where we shall be stretching through the matrimonial property law and the latest development that saw a court decide a few things that could alter how divorce is, well, settled, and who gets what, how is the computation done, and everything around that. Earlier this week, that was on Tuesday to be very specific, a unanimous judgment from a panel of 3 justices initiated suspense of disbelief and a bit of a dilemma in matrimonial resolution processes and legalities. The decision held the spouse's share in the matrimonial property is not an automatic half share, but instead dependent on his or her contribution to it. This highly contested discussion we've broken down into a little bit of depth to help us understand what is at stake rather. We are joined by Reyner Mugyezi, a legal officer at KAA. Many thanks for joining us this morning. We are also joined by Susan Nabatte, a legal officer, as well as Sylvia Namubiru, a legal officer too, and an activist with Last Minute. Many thanks for joining us. I'll simply begin from my extreme right, Sylvia Namubiru. What was your take? How did you receive the news of this landmark ruling when it came through?
Thank you so much, Hijin, and good morning, viewers. When, of course, I first received the news of this judgment, it was on social media. Yeah. And I took time to go through quickly what the social media had given as a summary of the judgment. That's right. But later on, I took time to read and internalize deeply the ruling of the land justices of the Court of Appeal, especially the lead justice. And I got my perspectives as a lawyer, and I was able to contextualize, yes, the judgment. We shall be looking forward for that context very shortly. What did you make, Mr. Reyner Mugyezi?
Thank you, Chris. In my opinion, I've had the opportunity of reading quite a number of decisions on the subject, not just in our jurisdiction, but also across our borders. Yeah. And what the land justices say really is not new. They haven't said anything that is truly a change in the landscape of this particular provision of the law. Okay. What they have done is that they have further pronounced it. And although it creates a very stark difference between the opinions of both gender, it's very important, at least for the development of the law, for the discussions like this to be had.
Okay, that's interesting perspective. We shall, of course, be looking forward to hear a little bit more on that. Susan Nabatte, what was your take?
Good morning. Good morning, viewers. Happy to be here.
You're welcome.
When I received the judgment myself, at first it seemed normal.
Wow.
Yeah, like these are judgments we've had even with the Supreme Court making most of these decisions. But when I dug deeper into the judgment, I found out that there were some things probably that could have had a change in the judgment, or that there are some things probably that could have been handled in context of our current situation in Uganda, or society, or the issues affecting women from this side, specifically because marriage is an institution. That's right. Which probably everyone looks up to. So I think it tempts more every adult to have something guide this institution. So when courts make these rulings, they really help to ground us in marriage. However, they also raised other reactions from different people. So,
wow, yeah. No doubt about that. It's a debate and a discussion that we shall be looking forward. But before we go into it, let's take a look at how the media covered the news of that particular ruling. those are some of the pictures there that were relayed. Of course, it's a court environment that is in line with this particular topic. We seem to be having a little bit of trouble there, but let me return to the studio and to our guests today. And I'll begin with Mr. Reyner Mugyezi. You've spoken about the fact that it was simply a pronouncement of what is already existing. We shall perhaps want to understand if it is something that simply carries forward realities that we face or that we deal with on a daily basis with regard to the institution of marriage and how the processes of dispute resolution are conducted. What then should we look out for in terms of what could determine a few things or could change how we resolve some of these disputes leading up to divorce?
Thank you, Chris. It's interesting when you're reading through cases, especially those of this nature. Of course, the very first thing that I would change is the identity of the parties. Like in the manner that you've seen in the media, and of course it's now going to be cited across several other cases every time it is referred to in a court of law. But I would have preferred there to be the same system, like where you use perhaps just the alphabet to say that perhaps A was married to B and A developed issues with B, and thereafter these are the issues that the court has to resolve as to whether matrimonial property, for example, should be divided in equal, like that, so that at least at the end of the day the principle of the law is pronounced and the identity of the parties is protected, and their I would say dignity is preserved by this sort of discussion. But that notwithstanding, there have been a number of issues in our history as Uganda. Not just Uganda, but across the world. Because even the laws that we have as a country, we did not come up with them on our own. We actually merely inherited them. And as soon as we did, we then had to take them in and then perhaps suit them to our circumstances as a country. So there have been issues in relation to distribution of property. There was a time when women were considered chattels in a marriage, where if I got married to someone, then the other person would be considered my property of sorts. And in some traditions, they were even passed on to say in one's will. But that position has changed. Under the constitution that we have today, the 1995 Constitution of the Republic of Uganda, at least we know that the rights of women are protected. We know that the Constitution sets it out that women are actually supposed to be treated on an equal scale. And on that, I completely agree. I agree that in a society such as this one, we all have an equal contribution that we can make to not just the development of the country, but also to pronounce our rights, social and economic, at least more out there. And what this ruling, what this decision of the court has done, is that it has just pronounced, as I had earlier pointed out, some of the decisions that had been earlier made. We had, for example, a decision which has been very widely cited, the Rabinumi case, where the position of the Supreme Court was to the effect that property that is acquired before marriage cannot be considered, say, matrimonial property. But if the parties, say, have the intention of acquiring the property together and living there together, then that should constitute matrimonial property. The issue that comes in is what happens if I am unable to, say, contribute either monetarily, but then I am bringing in a non-monetary contribution.
That's right.
And that's where I believe this case hinged. Because the issue in this case was a lady who had been, you'd say, an urban housewife. She used to cook, clean. They had a maid, according to the facts that we have seen. And the issue that was before the court wasn't whether they should divorce, no. The issue was how they should distribute the property between the two of them. On the petitioner's side, who was now the appellant, he was saying that he had a more substantial contribution. And as a result of having a more substantial contribution, the question was now on the respondent to then prove what contribution she may have had. So there were receipts that were adduced in court. There were...
Wow.
Yeah. There were statements showing that this payment was made here and there. There was a statement in relation to the construction of the house, in relation to cooking for the building masons, and being able to at least explain that I did have a more substantial contribution than what you are making it out to be.
All right. Yes. That's very interesting. Sylvia Namubiru, the institution of marriage right now is in a bit of a spot of bother, and it brings us to the fact that the whole movement of equality comes to fruition, as in it's now an institution of equals. In other words, if you have sat down and decided that you get married, and all efforts, whichever way it comes through, shall be seen within the light of the fact that you put something on the table, and that means if we are to sever the marriage, well, I deserve what I need to take. How do you bring this home?
I wouldn't say that the institution comes to equality, as you put it, but I would say that as Article 31 of the Constitution says, you are all equal, of course with equal rights. Which rights are interpreted? I think the issue that the Court of Appeal decides is what remains sticky, especially in issues of divorce. Usually the judges will find it very easy to find grounds and everything and all that. But when it comes to accumulation of property, always it is sticky. And it becomes the contentious issue. What counsel has not mentioned is that this case came from High Court, where the land judge had already decided and even gave an automatic 50-50 to the property. And so when the appellant came to Court of Appeal, he was challenging that. But he was also challenging the fact that this was not matrimonial property. Again, I think citing the case of Rabbi Numi, which says matrimonial property is property when you are married. This was property acquired when they were still cohabiting.
That's right.
They cohabited for 16 years and they acquired the property. So the appellant was making that argument. And I must say the courts confirmed that this was matrimonial property. And I think that is a good development in it, in view that we have not even had the Marriage and Divorce Bill, which was seeking to recognize rights of cohabitation. So the court said, no, this is matrimonial. But the challenge came again. Whereas the contribution is monetary and non-monetary, the calculation of the non-monetary element in marriage. And that is what is going to be a little bit subjective, given different interpretation. And when you come to equality there, you have to bring in also the element of equity. Because you see, this is a lady who has been with this man for over 20 plus years.
20 plus years.
Yes. However, the guidance that the land justices gave for now will continuously help the parties to understand what is the quantum of what I take and how is it computed. But it will be subjective and it requires further guidance, in my view, especially either by legislation and guidelines. Otherwise, you will find that someone's non-monetary contribution you can't have sufficient evidence to prove it because it's over a period of time.
Give us an example. For example, if I returned home, I'm the husband, and I didn't leave Kameza money, but somehow I find food.
Yes.
Is that suppose the computation process at that point would be, of course, very difficult for the
And how will you remember it over the years? The many times the husband left and did not leave Kameza, and I improvised as a woman. What about the day-to-day care of domestic care that I always carry out There is a lot that the woman does that how are you going to compute it? We are giving it a high level of degree of proof for this housewife to begin to add day by day the percentage that they put into. That is where I see a challenge. But nonetheless, the fact that now it's not automatic kind of guides, I can even end up having a 90% if you are not careful.
Okay.
But now it depends on how
you fight it.
Yes, how I fight it.
Exactly from what
and you go with your 10%.
What foundation you're coming from. If you're a lawyer, I can expect that. Do you agree with her? She knows how to fight it, so she can actually pull it off.
Most definitely.
All right, so what do you make of that? The fact that your earlier submission hinted on what I thought to be a case of too many gray areas with regard to the ruling, but you do hope that it will finally settle some outstanding issues.
Yeah. Maybe I could start by saying that dynamics have changed in marriage.
Yeah.
That before, ordinarily we had men working for families. Currently we have women working for families.
Yeah.
And like each is sharing responsibility. So when the courts have come up to say that we should not share equally, to me it's progressive. Progressive, it's protecting both parties. Because before, when the constitution came into place, it said, let us have equality between men and women. Article 31, 1B. Between men and women at the stage of marriage, in marriage, and also at divorce, which all this is are all expected for an adult. After them thinking like that, it seemed ordinary that if I marry you, I'm entitled for 50.
Yeah.
And every woman could be excited for that. But as I've said, dynamics have changed. So when we are changing now, because even in Namubiru, the same issue was raised. Should we do the 50? And then we are saying, look here, we have contributions that each party makes. We are looking at a weaker gender, or people, the one that people regard a weaker gender, that probably should contribute less. But if we are to follow these rulings, as Sylvia has said, in case I am this energetic person, or woman who can bring most of the things to table, and we are having divorce, at the end of that day, I might take an 80, depending on my contribution, if we are to evaluate. However, the danger in that is that, where are we leaving the sanctity of marriage? Are we breaking the trust in marriage? Because if we are looking at getting married, I think now the vows are changing. Religion versus the law. That's where we are going. Is that if we're looking at sanctity of marriage, what is the intention now that we are getting married? If we know that at the end of the day, I have to bring a receipt for each and everything. So I'm going to start out, if I'm contributing to, let me say, my husband constructing a house, I need to keep a receipt for cement. I need to keep a receipt for this. But also we have to understand that the society we live in, most of the women, I don't know, this case was for an upper woman, but also have the women at the grassroots, where they have taken patriarchy as their daily food.
That's right.
Yes, is that a woman will go with a man to purchase certain things, but because he's the man, the receipt definitely has to come out in his name. And that contribution won't be assessed at the point of the divorce that we are talking about.
I'm seeing a scenario where the receipt at the table are on a, well, if married people these days also still do dates, where the waiter and the waitress brings the receipt and hands it to the man and not necessarily to the lady, because of the assumption that it's the man that has the money to pay. I'm looking at a scenario where a lady gonna have to keep that receipt too, in case they're the ones that paid for that particular
in case
evening.
Things go wrong.
It's interesting, but let me return to Reyner, Mugyezi, and the fact that you said it simply pronounces something that has been with us. I look at this within the context of the white community, where we see so many of divorces rampant, and you begin to think perhaps they came to this point a long time ago and realized that they needed to settle the things, prenuptials, being able to sign up a few things and saying this is what I can agree to, or this is what I will bring on the table, and this is what I'll allow to take or agree to take. Do you see us reaching the level of the white community, Western community, where marriage is typically a contract?
Absolutely. Absolutely. I actually think we're already there.
We're already there?
Yeah, we're already there, because I myself have prepared quite a number of prenuptial agreements. Mm-hmm. And it's not yet exactly one that has been adjudged on the basis of its merit before a court of law. But it would be an interesting scenario to see where I, Party A, have entered into a marriage and have agreed with Party B that in the event of divorce, this is how much you will take and this is how much I will take. But it's a very interesting, at least, scenario, because you see, whereas my colleagues believe it is adding a bit of what you would call a blind spot in relation to the sanctity of marriage. Yeah. What it's also doing is that it's also redefining or making it clearer that if I come into a relationship and I am bringing my contribution, then I must be able to at least value that contribution. In fact, the biggest issue that this case brought up, which I am yet to maybe perhaps agree with my land colleagues here, is that this gentleman went and said that before the High Court, the judge of the High Court was biased against him and did not take into consideration that he had added value to this woman by paying for her school fees to go to Nakasero Primary School, and then thereafter to attain a certificate and a diploma. And he was saying that ought to be taken into consideration in determining how much that person is entitled to and also taken away. So the effect of that, in my opinion, is that now every time say my wife is going to the salon, instead of giving that money on Kameza, like in cash, I'll have to put it on her bank account.
Mobile money.
Oh, mobile money.
So you have
perhaps where you have like a statement of sorts. You know, the law can be an ass. Forgive my French.
Yeah, we've had that. It's
right?
It's all right.
But it's what it is. At the end of the day, the court is faced with a decision of how much should I give. And it's a very absurd one, because now they're then saying that, okay, you should give perhaps what you should put in. But then how do I quantify it?
Yeah.
All right. Staying with legalese could be a little bit hard for the average Ugandan out there. Let's return to the court of public opinion and how the public sees some of the things. There are many incidents where men and women in equal measure have supported their spouses or girlfriends or mistresses to attain education. The reason is simple, I believe, is that if you love somebody, you want to see them better.
Yes.
And education enhances a person's ability to make more money, both for you and the family, but for herself too, because we all want somebody who looks good, who speaks well, and is of value to you, the family, and everybody else. Now, does that mean, for example, if, or this particular ruling, could it lead us to a situation where if you're not educated and you're in love, things are bad for you? Because somebody might be like, okay, if I have to invest in your education away from the beauty that you bring on table, this is what is going to happen. We are going to agree up to university. Are you in on this love or not? And then somebody's like, well, I might change my mind later when I become better and more attractive, more valuable. I might change my mind too. Where are we heading on this?
First of all, to start with, we should not, within the context of the African culture, let us not go Europe. The intention of marriage.
Yeah.
The intention of marriage is to live together, stay together for life. And before you get married, of course, there is what we call consent.
Consent.
But you must also have fallen in love. Emotionally, you are attracted to this person.
That's right.
You love the best, and you want to give the best.
Yeah.
But just like any other society, like anything that moves and transforms and goes and changes, sometimes there is falling out of love, or there is committing what we call acts of offenses in marriage or grounds that occasion that you have to be apart. Now, at the divorce time, that's why now the state comes in. The way the state comes in to regulate you when you are getting married and determine the conditions and terms of marriage, the same thing comes in for the state to regulate you using the courts of law to help you part, but with less, I don't know, acrimony. But you want to understand that at that time when you are parting, you know, emotions are changing.
You're changing.
You know, there's a thin line between love and hate.
That's
at
right.
that time, the hijeni I fell in love is a hijeni that has become a problem. And I'm looking at all my investment that I put in him. Everything, the emotional investment and everything. So I'm like, I think I need to be indemnified, what do you call it? Remedy. To compensate for my emotional input, physical input, everything. So whereas we may say that people or intending parties will not get married because of what they see in the future, we should say that we should remain as we are. Because not all marriages go wrong. Not all marriages end up like this one we have. So it's very important to go for the initial and the intention of marriage. However, when it happens, we call it fate. And that fate, we should ensure that when we part, we have children. And we have to harmonize. And that's why the court is an arbiter and comes and harmonize and say, okay, you did not prove a lot that you contributed, but at least go with this. The area court, the court of the High Court, in her wisdom, the land judge had saw that the 50-50 would really be good.
That means the land judge of the High Court was considerate of aspects you speak about, the African settings, the emotional aspects, something that you could correctly say the justices of the Court of Appeal did not bring themselves to. And should that be something?
They did, and if you heard what counsel talked about the transformative, the input of this gentleman transforming this lady. When you read the facts and details of this case, you get to know that the issues of contention and what caused them to be apart is really deeper. And I don't want to go into it.
Interesting.
But they did and said, if this man invested in you and later on you moved out, desertion and etc. and etc. So we think that the investment at that time, he thought you were going to stay as a wife. So they computed that. So you wouldn't say that they did not take into consideration of all that. You see, it is very interesting when legal minds are interpreting. The one at the High Court was alone, but these are three justices, and they are weighing in on all the grounds of appeal. And they were very fair, because the first ground failed, where he was saying it's not matrimonial home. The second, third, and fourth, I think, succeeded. The third of bias failed. So when you begin to analyze the judgment, you wouldn't, in a way, unless the Supreme Court later decides, because it's still subject.
Interesting there. We could see a protracted legal battle, one that could lead us to the Supreme Court, as you say. But let me come to Susan Nabatte. The increasing monetization, and this one is relative, depending on where you see things from. There are people who are seeing marriage and the intention to marry as increasingly hinged on the monetary aspect, so much so that some find relief that the court has been able to say you're going to have to quantify the contribution that you have brought on table. Do you think it's going to complicate things for the female folk, especially who are greatly disadvantaged when it comes to this?
I look at it in twofold. As a family lawyer, most of the times, let me speak for my community that I represent most of the time. The things we bring into marriage are beyond money. That's why even when the land justices were interpreting, they looked at very key aspects of monetary and non-monetary. And that is very important. So when you look at monetary, you're looking at conditions where one of the spouses is not bringing money on table. Probably you're investing, I'll give you scenarios. Probably you're investing into the home as a man. which is partly your responsibility, but you're investing more into the home. Then the courts are saying, in the interest of justice, do not just go like that, or aggrieved that the woman has taken all my things. However, when they go into the aspects of non-monetary, and they look at the aspect of the care that we provide in the home, even in the ruling, many issues came up of you didn't do this, you didn't do that, you didn't do that. No, Ispin was paying the workers. Many things were in the ruling, yes? But in a contemporary situation where, let me say, women are home, I'll not only talk about stay-home moms, even women who work. We do a lot of things in the home. So the issue that will come in now is that how are we going to quantify these non-monetary contributions that we are bringing on the table? Let me give you a scenario. The love and care and affection that we extend. We might not say let you pay for it, but it is adding to your esteem at work.
That's right.
Probably it's making you work better, make more money.
Relationship psychologists and people or counselors often say that how you are sent off to work by your wife determines a lot of what will happen that day.
Exactly.
So much so that if your wife has, for example, declined to offer the peck, honey, have a good day, that could also affect you if you are the lovey-dovey. Yes. There are some who don't even think a peck or a kiss or even have a good day, honey, is something they should look out for. They're just like, hello, the money is on the kameza, everything is okay, see you later.
The typical African man.
Typical African man.
Yeah, typical African man. So from that, the contribution is beyond even the housework. That when I decide and say that let me be taking these children to school every morning so that my husband can wake up very early and get the earliest client, probably is going to give us our paycheck. That is a contribution. If I wake up and I say, okay, we are inspecting the site. In this case, I was actually very sad when they said that the woman had just gone to spectate or tour.
Wow.
It came out like that.
That wasn't right.
It definitely came out like that.
For sure, that wasn't good.
But let me tell you, in situations where we live, even if a woman is not educated, she could inspect a site.
Yes.
The inspection is not that how many bricks have you put onto the next floor. No. It is our material being utilized. And this case, even doing something that looks good on the eye. Not everyone person I'm educated, but I might not know how they are constructing. So I didn't agree with that assessment of because of her level of education and skill, she would not go there to do something constructive.
Reyner, I just want to. There's a lot you're jotting down.
That's a whole book.
It's a whole book, and your submission could be really, transformative to this whole discussion. Please do put us up to speed with what you're noting.
No.
Okay. Let me ask you the question.
Yes.
Could this, in an effort to resolve an issue between two people, kind of open a Pandora's box for a lot more millions? Yeah.
Well, I would say it could, and I would put it at 50-50.
50-50.
Forgive the pun, so to speak.
Interesting.
But the issue amongst many of us is that we seem to all be interpreting this very, very differently. Yeah. And especially in relation to how we, as the society, look at marriage and what exactly it's supposed to mean to each and every one of us.
That's right.
So say, for example, my land colleague Susan said that issues like the love and care that a woman affords, right? But you see, the man also gives love and care.
Yeah,
right?
Sure. No doubt.
Sometimes.
And then I think it's an arguable thing.
Yeah, of course.
Because whereas you might not be looking at it that way, an urban housewife will worry about what the home will look like whether there is food, whether the clothes are clean, whether the house has been cleaned and what
color
and I believe that labor,
texture of the curtains.
Yes, that labor is what would be referred to as non-monetized. It's what would be referred to as that extra contribution that I would be putting somewhere else, which is what the economists refer to as opportunity costs. But then I am putting it into, say, the growth of the home. You know, but then that same say respondent, or the woman in this case, I'm giving the example. I'm not saying that all women cook, but like in a home in which, say, the wife or the woman is cooking.
Is widely expected.
Yes,
to cook.
She will make it seem like that cooking is a favor to the house, right? Whereas she will not point out that I am the one who bought the food she's cooking. You get what I mean?
I do.
There seems to be at least an imbalance of what we consider to be important to us in a social setting, such as a home, which is the very basic.
Let's flip this and say Chris is in a marriage and he doesn't have a job. He didn't go beyond senior 4, meaning he's unable to get employed in a formal setting. He's also, I don't know what else to add. Somebody could, let's imagine it is the lady that is doing all the paying of the bills and even doing the construction of the house. Quantification of my care at that point in time that I bring on board will also be an issue to debate. How will that be? Help us.
How will it be? Definitely will depend on how you bring what you have done, as the woman was doing all the other, concerning the physical, the monetary, and ABCD. But I want to say that in this judgment also, the land judges did not help, justices did not help us. How did they arrive at the 20%? After the monetary and the non-monetary. How did they quantify the non-monetary? So that they say, it is not 50, it is 20%.
It is 20%.
I found that still not, it wasn't clarified.
That's a gray area.
It's a gray area. But the way it was interpreted for the lady would definitely be the way it is interpreted for you. Because then you are the housey. The other one is a housewife. You are the house husband.
House husband.
Yes.
That's interesting.
House husband.
Houseman.
Yes. But I want us to understand that, of course, yes, we are bringing all these elements of monetary, non-monetary, but we need to go back to the basic, the intention of marriage.
The intention of marriage. So it seems that this landmark ruling, like I said, on top of, apart from, away from opening a Pandora's box, it's also a point of reflection and food for thought for the judicial structures. How are people, justices, going to handle cases like this? Do you need to pay attention to the emotional, the settings within society? Because you could completely change how things are. Is that itching?
And burden of proof of that.
Burden of proof.
It is a huge burden, especially for that disadvantaged woman.
Disadvantaged woman. Take us through.
So for the scenario you mentioned earlier, the situation will simply flip. Man-woman. That it's the man who is actually now been providing all these things in your absence, which some men do, and we cannot actually neglect that fact.
That's right.
There are those men who are stay-home men, and they actually take care of their homes in that setting with whatever they can, even if it's the helping with the dishes. I don't know how they do it. Probably, yeah.
We haven't experienced it.
Yes, but when we try to quantify the non-care work, yes, because the world has changed, whereby almost every household now has a maid, yes, has a maid or a casual laborer, someone who is helping out with the work.
Daily stuff.
So we need to know that as courts go ahead in interpreting all these judgments, what we have to keep in mind is that case-by-case basis, because cases are going to differ always. They are going to have different scenarios. Is that even the emotional support or the help that I'm extending in this case might be different. You can find now, if it was another scenario outside this case, probably the woman was doing everything besides the money. But also what I wanted to point out that if we are considering the non-monetary quantifications, why are we going back to the how should I call them? The things that come naturally in a marriage. You see, in this scenario, I think the last ruling, they dwell on the fact that the man had actually contributed to her elevation in terms of education.
Transformation.
Transformation. And courts go ahead and put that into consideration in quantifying her non-monetary contribution. Yes, to arrive at the 20, probably they cut off a whole 20 because of what the man had done. But remember, every time we are in marriages, someone is bringing something beyond what the eye meets, what the eye meets. Yes. So if you decided to offer me education, which we really appreciate the men who do that, you're doing an economic empowerment on our women, but let us not have that tension that if he's doing it, one day, one time, you will pay for it.
Of course, there is.
I think that is a bad thing that we are now painting for marriage.
Paying tuition for your spouse is more like intellectual makeup.
Yeah. And it's helping the both of you. Yeah. Like we are having good children and teach them English.
Just a moment. Let's see how the public reacted to this particular development when that news came through that the court had ruled as such. Our reporter was at hand.
And Christopher Gashurabake finally resolved a 10-year divorce case between Joseph Ambayo Waigo and Jacqueline Aserua, residents of Mbuya Mutungo in Kampala. In the landmark ruling, the consequences upon the sharing of matrimonial property after conclusion of a divorce are that marriage does not give a spouse an automatic 50% share of the matrimonial property. A spouse's share in the matrimonial property is dependent on his or her contribution to it. One's contribution to a marriage can be both monetary and non-monetary, or both. Non-monetary in terms of unpaid care rendered by a spouse during the marriage, like caring for children, elderly, sick relatives, household chores, and cultivating food for the family's subsistence, among others. Where one party has in the course of the marriage contributed towards upgrading the other spouse in terms of educating him or her, such contributions should be deducted from the beneficiary spouse's total claim. Article 31, subsection 1 of the Constitution provides equal rights to husband and wife during the marriage and dissolution. Reyner, Mugyezi, an advocate, says there is no mathematical formula to quantify how much one should get when it comes to sharing of matrimonial property when the marriage is dissolved.
Whereas one court was saying that you should do 50-50 because the law now says equal parity. Equality is equity, as they say. The Court of Appeal was of the opinion, and they also agreed with a previous decision with the Court of Appeal in Kenya, that was to the effect that it is not that easy. The circumstances of each case should determine the outcome.
The Court of Appeal is seen as being progressive by recognizing that one's contribution to a marriage can be in either monetary or non-monetary form. The quantifying of non-monetary contribution being doing domestic work, taking care of children, cultivating food for the home, and caring for the sick members of the family, according to Victoria Mufumba, a strategic litigation officer with the Uganda Association of Women Lawyers, FIDA-Uganda, will have an effect on the institution of marriage.
The sanctity of marriage is being diluted or played around with when we have to tie unpaid care work to a certain market value, which we do not even have.
Members of Parliament also weighed in on the matter.
How much are you going to pay me for having sex with my husband? Does the church even allow that? How much are you going to pay me for ironing your shirt every day? So if we've been married for over 50 years, you're going to pay a dry cleaner in your wife. How much are you going to pay the women for being chefs, for being nannies, for changing diapers? I think for me, that totally fell short.
Our judges are very correct. You know, we have other women who are target workers. There are other women who get married strictly targeting the property of that particular man.
Mugyezi says that evidence before a court of law is usually primary, but in matters where there is none, then the court can look at the secondary and collateral matters. Many Ugandans think that having receipts as evidence of their contribution to the marriage, in case they ever are in the courts seeking a dissolution of marriage, is a solution.
If I got a client who had receipts and showing that I bought this amount of juice on this day, and I used this amount of money, or on the basis of equal distribution of resources, I would bring in, say, 500,000 into the home in a week. That information would be of great evidential value in a court of law, but not necessarily in a marriage. So you might want to be careful.
Then there is the ruling on where one party has in the course of the marriage contributed towards value addition to the other, say upgrading their spouse in terms of educating them. The court said that such contributions should be deducted from the beneficiary spouse's total claim.
Seems to me to be the biggest issue. It's not enough that I have increased your value in terms of education. But if I feed you well enough and you then start looking healthy, and every time you step out, they compliment you and you look good, and do I not then take that into consideration? If I am not the kind of gentleman who gives you distress at home, and every time you show up at work you are even more productive and you are happy, and you'd be a delight to be around, I myself, knowing that that's not really an easy feat, would take that into consideration.
According to the facts of the case, Aserua and her husband Ambayo started cohabiting in 1989 when she was 19 and he 24. The Constitution does not consider property which a couple acquired during their cohabiting period as matrimonial property. Rita Kanyamujuni, NTV Tonight.
All right, many thanks Rita Kanyamujuni for that report, and of course the reaction, especially from the members of parliament, was very poignant. Each seemed to see things from their point of view, which we cannot actually begrudge, because
it's a polarized issue.
Polarized issue, no doubt. Do you see a scenario where I alluded to this earlier, the fact that this could open a Pandora's box, and do you see more court cases coming up? I could come to you. You're directly involved in family law.
Yes, I think we cannot dispute the fact that we have so many divorces happening around the country, and that's for very many reasons, even beyond the grounds that are stated in the Divorce Act. But it's just a way of finding a way of fitting it within the law when we are doing all these divorces. But yes, where we are going, we are envisaging many people now trying to say that this is my way out, if I should put it that way. This is my way out. That I've accumulated this, but now court is telling us this. But what we have to remember is that judges have discretion. They follow all these decisions with reasoning. That, and as I mentioned earlier, the circumstances will always differ. That if your circumstance doesn't fit within these circumstances, a judge could rule otherwise. Yes, and the other party has a right to appeal if they do. Though when you have court of appeal decisions, they set precedents. But you also have Supreme Court decisions like they've been around that courts are using always, even in this case, they're using always to set the parameters of what is going to guide divorce and matrimonial property. Yes, but the question of will it open a Pandora box of divorces? We're already having them, yes? But the question would be, now people are going to be more intentional about what they are doing in the marriage, because it's opening, it's an eye-opener at some point, but also it's more of a restriction. Should I do this? Should I not do this? Should I do this? And that is going to be a very big problem, even with our divorce cases that we are handling always.
All right, Reyner Mugyezi, wrap this up.
Yes. Thank you, Chris. It's a very polarizing issue. At least on that we can agree. What this particular case has shown, and what the difficulty of the judicial officers has shown in determining this matter, is that there is a need for this to be put before Parliament.
Yes.
The people's representatives need to sit down, look at the considerations that would be required. Because, for example, the law that we were using prior to this is perhaps, it has been overtaken by leaps and bounds in other countries like the United Kingdom. So, in my opinion, it creates, it's a restatement of the existing status quo. But it's something that we need to consider in relation to what we look at as marriage in our society today and what we hope for it to be in the coming years.
Forward. Yes. On a lighter note, as I close,
the marriage and divorce bill should be brought off the archives, brought back to Parliament. We need percentages for non-monetary contribution. Once it is cleared, then the courts will decide according to percentage.
Last question for any one of you. If I was gifted a Range Rover, the receipt is there. That one is easier to quantify, right? What contribution I brought to the marriage.
You might have gifted
a Maybach, a Mercedes.
And it's in my names.
Oh, okay.
Yeah.
Interesting.
So there we go now to the legal things. It's mine by title. I mean, the logbook is in my name, so there's no debate there.
All right. Many thanks, Susan Nabatte, a legal officer, and from FIDA-Uganda.
Yes.
No doubt about that. We've also been hearing from Reyner Mugyezi, an advocate at KAA, as well as Sylvia, Namubiru, an activist from LastNet. That we needed to make very clear. That will do it for the Kickstarter discussion. It's been wide-ranging, and of course it will continue across the various platforms and in other circles across the country. I'm Chris Higenyi. Let me now go for a break, but later we shall be hearing from Stephen Mbide, who has issues on the ground to talk about.